Yeah. So today we are going to deal with the paper 2 of our first semester, which is Family Law 1. So in the first semester, you all are going to deal with Hindu law. In the next semester, you people are going to have this paper 2, Family Law, which pertains to Muslim law or the Mohammedan law. So don't think that it only relates to Mohammedan law. Also, you will find laws based on Christianity and all other things. You also come across other such provisions also. Yeah. So this semester we are only going to deal with Hindu law. So what is the source of Hindu law? From where did Hindu law came from? So, Hindu law came from. So, what does actually source of law means? Source of law nothing but from where the law has come from. Okay, from where did it originated from? So here we can say that Hindu law originated. I mean, the term Hindu originated from the word Sanskrit word Sindhu, and then it got, yeah, with the passage of time it got the term Hindu. So, who is actually a Hindu? A Hindu is a person who follows Hinduism. Okay, so personal laws. What do you think are personal laws? Laws are those which govern matters such as, governs matters such as the social life of Hindus. Social life in the sense which deals with marriage, divorce, adoption, inheritance, guardianship, and other such family matters. Okay, so Hindu law is complied with, in the sense, in under Hindu law you find various laws pertaining to marriage, divorce, adoption, so on and so forth. Okay, so there are acts such as Hindu Marriage Act. Okay, then Hindu Succession Act. So all are these things which are going to find in Hindu law. Okay, now, yeah, it is believed that Hindu law is a divine law. Why do we call Hindu law as a divine law? Because it is believed that it was revealed to the people by God through the Vedas. It means that God has told the divine law to the sages. Okay, people in the sense we believe them to be as sages or rishis or munis. So God has uh, revealed this divine law to the sages, rishis, and munis through Vedas. Okay, that is why we call Hindu law as a divine law. Now, various sages and ascetics. Ascetics are nothing but monks, sannyasis, and all of those people who have yeah who who have renounced the world, all the worldly pleasures they have given up. So, yes, sages and ascetics are one and the same. They mean sannyasis, monks, etc. So, various sages and ascetics have elaborated and refined the abstract concepts of life explained in Vedas. So, in Vedas, it is written in a comprehensive language. No one can make sense out of that. That is why we have sources of Hindu law here, ancient sources as well as modern sources. So, ancient sources we have Vedas and all other things which we'll be seeing. So, mostly it is seen that in Vedas it is in abstract form, in the sense it is not in elaborated form. Only superficially it is defined there. In the sense, partially it is told there. Okay, like Vedas have not spoke about uh, inheritance rights of a widow. I mean, a widow having getting rights from partition. So all those things are not written in ancient law. So in that case we resort to modern sources. What courts have told, we'll be seeing in modern sources. So ancient sources is to do with only the Vedas and all other things which we'll be seeing now. Yeah. So the Hindu law is credited to be the most ancient law system. It is the oldest of all. Okay. So it is believed that it is approximately 6,000 years old. Okay. Now, sources of Hindu law can be divided into two sources: the ancient or the original sources. These are the oldest sources. And we also find modern sources. So, modern sources, as the name says, they are like of the recent origin. Yeah, ancient sources. The first one under ancient sources is Shruti. What is Shruti? It derived from the term Shru, which means to hear. This is a Sanskrit term Shru, which means to hear. According to this theory, it is told that huh, in this theory, it is the primary and paramount source of Hindu law and is believed to be the language of the divine revelation through the sages. So, what I told, because I told you that Vedas were those which the god themselves has told to sages. So, Shruti is nothing but that thing. Okay, so what sages had heard from God is believed to be included in these Shrutis. Okay, so the material heard by the people constitute Shruti. People in the sense, as I have told, sages and Rishi Munis. So it is believed that Shruti contains very words of the deity or God. Yeah. So Shruti comprises of four Vedas: Rig Veda, Sama Veda, and so and so. The it Shruti, apart from Vedas, it also constitutes six Vedangas and 18 Upanishads. So, if you all know, these Upanishads, Vedas, all these principles are taken into many of the uh, what do we say, constitutional aspects. Like even in our constitution, we have taken terms such as Satyameva Jayate. Yeah, all these terms are included. From where they have been taken, they have taken from the ancient sources of the Hindu law. So Shruti comprises of Vedas, Vedangas, and Upanishads. Yeah. So it is believed that rishis, munis had reached the height of spirituality where they revealed the knowledge of Vedas. Because they do penance day in day, whole day, it was believed that those people had the knowledge of all these concepts. So Vedas, what does Vedas contain? Vedas primarily contain theories about sacrifices, rituals, customs, how a particular marriage is supposed to be conducted according to Hindu law, is where is written where it is written in Vedas, and all the other customs which are to be followed are included in Vedas. Okay, and remember, Vedas are a part of Smritis. Now, since Vedas had a divine origin, that it is believed that it is revealed by the deity, the society was governed as per the theories given in them. Okay, so society, what is right and wrong according to Hinduism was governed as per the things which are included in Vedas, Vedangas, and Upanishads. Okay, so Upanishads are also known as Vedantas or concluding portions of the Vedas. Okay, so and these include the highest principles of Hindu religion. What a particular, if a person is a Hindu, what are the principles which he is supposed to follow? So all these are included in Upanishads, which are the concluding portions of Vedas. Okay, so Vedas do refer to certain rights and duties, forms of marriage. In those days, there were many forms of marriage. So, yeah, also the ancient Hindu law places, uh, what do we say? It places a high, yeah, it gave importance to son, unlike daughters. Okay, so any couple having a son, they were respected in the society, and if a daughter was born, you know the thing. So, exclusion of women from inheritance and partition was also seen. And that is why I told you that there were no specific laws relating to women having a right in inheriting a property or having a right in partition of the property. Yes. Now, the second source of ancient law is Smriti. The word Smriti is derived from the root smri. It is a Sanskrit term, smri, which means to remember. Traditionally, Smritis contain those portions of the Shrutis which the sages forgot in their original form. So, according to my understanding, whatsoever the sages couldn't include in Vedas, okay, whatsoever the deity was saying, which they couldn't include in Vedas, was then included in, I mean, whatsoever they retained, they included them in Smritis. They wrote, uh, they wrote, uh, they wrote in their own language with the help of their memory. What they retained in their mind, they composed into Smritis. So, according to jurisprudence is nothing but knowledge of law or study of law. So, the words remembered are those which were heard but were forgotten. So, through a series of meditation, they recollected. The rishis and munis happened to recollect those words, and then they put them into smritis. Okay, now again, smritis are divided into three categories: achara, which means relating to morality. Okay, principles of morals, what is good, what is bad, right and wrong, includes, I mean, means the achara. Now, what is vyavahara? Vyavahara is to do with procedural and subjective rules which the kings or the authority who is in power applied for settling of disputes and providing justice. That is to do with vyavahara. Then what is prayashchita? Prayashchita, thing, the third category which is laid down in Smriti, was to do with the penal provision. Penal provision is to do with the punishment. What sort of punishment is to be given for what sort of crime? What was included in the third category, that is to do with prayashchita. So Hindu law believed in the philosophy that for every wrong, that person has to undergo this prayashchita. So this prayashchita can be done only when he is given some punishment. Only then he can have that uh, realization that he has done some wrong. So prayashchita is to do with that. So there are two. So in the Smriti itself, we have two other kinds. So yeah, their subject matter is almost the same, but then because it is early Smriti and later Smriti, we have divided them into two: Dharma Sutras and Dharma Shastras. Yeah, the first one, Dharma Sutras, were written in prose format. So they included some short maxims, like they were a shloka kind of. Uh, the Sutras were written from 800 to 200 BC. So they, yeah, as I told, they mostly contained of shlokas or verses, as I have told. So it is clear that they were meant to be training manuals of sages for teaching students. Okay. Now, they incorporate the teachings of Vedas with local customs. So, with the help of local customs, they used to, yeah, they really bear the names of the authors. So, how can we know what, I mean, mostly all these things, in today's circumstances, all these things will be known only to the Brahmin community. But then, yeah, we are supposed to read in our Hindu law class. So some of the sages whose Dharma Sutras uh, were very important were Gautama, Baudhayan, Apastamba, Harita, Vasishtha, Anigras, Yama, and all of those. So what did these Dharma Sutras contained in them? So they explain the duties of men in various relationships. Okay. Now, for example, Gautama, he belonged to Samaveda school. So there were many sages who belonged to many such schools. Okay, I mean, to various Vedas they were affiliated. So here we have this particular sage. Yeah, so here we have this particular sage Gautama who belonged to Samaveda school, and his Dharma Sutras dealt with exclusively with legal and religious matters. Okay, so in that sutra, he talks about inheritance, partition, and stridhan. Okay, now Baudhanya was another person, another sage who belonged to the Krishna Yajurveda. In Yajurveda itself, there are many other forms. So Krishna Yajurveda school he belonged to, and probably from Andhra Pradesh. He belonged to Andhra Pradesh. He talks about marriage, sonship, and inheritance in his Dharma Sutras. He also referred to various customs of his region, such as marriage to maternal uncle's daughter. So this particular thing which we see in Andhra Pradesh is, contained in his Dharma Sutra. Whose Dharma Sutra? Baudhayan's Dharma Sutra. In the same manner, Apastamba is another sage. His sutra is now well preserved. He also belonged to Krishna Yajurveda school from Andhra Pradesh. His language is very clear and forceful. So he rejected this particular concept of Prajapatya marriage. So we are also going to deal with various marriages which were performed in the ancient times. So then we'll know the meaning of Prajapatya marriage. Now, another sage, Vasishtha, he was from North India. So he mainly propagated Rigveda. He belonged to Rigveda school. He recognized remarriage of virgin widows. So, in this manner, each and every sage came up with Dharma Sutras, and they put in some customs, they followed some customs that was put in Dharma Shastras. Now, in the same manner, we come into the later Smritis, which are Dharma Shastras. So, Dharma Shastras were in poetic form. These are the shlokas. Okay, these are the shlokas, those were the verses. Yeah. Now, Dharma Shastras were mostly in metrical verses and were based on Dharma Sutras. So, as we have told before that there is no difference between both of them. Only a thread, only a thread difference is seen. So these are like based on Dharma Sutras only. Shastras are based on Sutras only. However, they were a lot more systematic and clearer. Occasionally, we find shlokas in Dharma Sutras and Sutras in the Dharma Shastras. Yeah. So Smritis mean what is remembered. Okay. What is remembered is Smriti. What was told is Shruti. So which Smriti, a systematic study and teaching of Vedas started. Many sages from time to time have written down the concepts given in Vedas. So it can be said that Smritis are a written memoir of the knowledge of the sages. So it is written, Smriti is to do with sages. They have done it applying their own mind. Okay, they have read the Vedas. Vedas are like first hand form. Smritis are what they captured the data from their meditation, what they actually what they remembered from their meditation. So it enlarged their scope of thinking meditation. Based on that, they went on to draft Smritis. So immediately after Vedic period, a need for the regulation of the society arose. Thus the study of Vedas and the incorporation of local culture and customs became important. So it is believed that many Smritis were composed in this period. As we have seen, many Smritis we came across given by various sages, and some were reduced into writing. However, not all are known today. Okay, so only the main ones are followed in today's world. From the history above, the fact which becomes obvious is that Vedas were divine laws, while Smritis were more of secular laws dealing on morality and religion. So Vedas, as we have told, deity himself has uh, dictated. Okay, dictated. So that is why they were called as divine laws. That is Shruti, and the Smritis were secular ones dealing with morality and religion, which is to do with the sages from the meditation, getting to know of them and writing, yeah, noting them down. Yeah. So the Smriti were accepted as statements of laws and they became an effective source of Hindu law. So, the laws laid down in Smritis include law on morality, procedural, and substantive rules. Procedure in the sense procedural in the sense what procedure is to be followed. Substantive rules means what are the rights and duties involved. Okay, applied in the adjudication of disputes, penal provisions. So, even in those ancient laws, for a person who has committed a crime or any offense, it was laid down like in what manner he is supposed to be punished, what punishment he is supposed to undergo. Okay, so even in such ancient law, all these things were included. So, where all these things were included, they were included in Dharma Shastras under Smritis. So, this was the second uh, kind of Smriti. Now, Dharma Sutras were the legal maxims as we have seen. So it was from these that Manu, Yajnavalkya, Narada, and other have drawn freely. So these words are these persons are important in the Hindu law. So Manu Smriti, we people have, uh, you all might have came across this. Manu Smriti is of paramount authority. Whatever Manu said was like a medicine. We believe that he is the first person on earth. Okay, so, yeah, it was a collection of laws and also the theological and metaphysical speculation. So, whatever Manu said was, contained all the laws. So, next in order comes Yajnavalkya Smriti and Narada Smriti. So, yeah, these are like, Smritis are named after persons here, mostly the sages. So these three smritis are very important: Manu Smriti, Yajnavalkya Smriti, and Narada Smriti. So here are many other such things like we'll come across Mitakshara and Dayabhaga in our tomorrow's class where we deal with schools of Hindu law. So there you will find that Mitakshara. So basically, there are two schools of Hindu law. The first one being Mitakshara, which was given by Vignaneswara Rishi. Another one was Dayabhaga, which was by Jimuta Vahana. Okay, so both of these are uh, the schools of Hindu law which govern the school of Hindu law, which we are going to see in tomorrow's class. So, yeah, let us come to this thing: Manusmriti. This is the earliest and the most important of all. Okay, it does not only define the way of life in India, I mean the Hindus, but is also well known in Java, Bali, and Sumatra. Okay, so to wheresoever Hinduism spread, it spoke about them. So the name of the real author is not known, but we call him to be as Manu. So the name of the real author is not known. The author has written it under the mythical name of Manu, who is considered to be the first human, first person. Yeah. So that is the Manusmriti, Yajnavalkya Smriti. Though written after Manusmriti, it is very important Smriti because its language is very direct and clear. It is also lot more logical. So it also gives a lot of importance to customs, but hold the king to be below the law. So yeah, even in today's world, we see that only the law is at the highest position and everything else is below it. So that concept is taken from Yajnavalkya Smriti. So in this manner, we can relate Narada Smriti. So Narada was a sage from Nepal, and this Smriti is well preserved and its complete text is available. This is the only Smriti that does not deal with religion and morality at all, but concentrates only on civil law. Civil law is to do with the civil aspects, such as property and all of those things. Okay, yeah. Now, the another source of ancient law, I mean ancient Hindu law, is custom. So the third source of ancient Hindu law is custom, which also means sadachara. So remember this word sadachara because there is high probability that you will find this term in exam. So examiners are like sometimes use the old Sanskrit terms. They'll ask sadachara. All of a sudden we get confused what to write, but then it is nothing but custom. So custom, the usage of virtuous men. It was not a written law. Now, so we follow some customs, but mostly it is not written at all. It is just like passing on from ages to ages. Our grandfathers did, great grandfathers did. So all our ancestors are following this customs, which is never written in nature. Okay, we are just following. We have been told about to follow such and so custom, and we are just following it. So we can say that it is not a written law, but it grew from the consent of all men. So just it was like everybody used to follow. All of them gave their acceptance to follow such a custom. That is why we are following. Even today we are following many such customs. It is because we all are agreeing to it, only then we are following it. Yeah. So custom as defined by Austin. Austin is a person, is a jurist actually. So he defined custom as the positive law enshrined by judicial recognition upon pre-existing custom. So jurist defines them in this language only, which we are supposed to remember. So as per the word sadachara, the practices of good men, what a particular ordinary man who has some good values is supposed to uh, is a man who is a good man who has some good morals, so were considered as superior evidence of the prevalence of dharma. So this good man has some dharma in him, so that is nothing to do with sadachara or the custom. Yeah. So custom came into existence when human beings came to live in groups. So it was but natural that they should, for harmonious group life, conform to certain patterns of human behavior. So, yeah, when human beings started to live in groups, only then came customs into picture. So, there were defined patterns of human behavior, what one person is supposed to do in living in that particular community, what he is not supposed to do is to do with the custom. So, as defined by the judicial committee, custom signifies a rule which, in a particular family or in a particular class or district, has from long usage obtained from the force of law. The long usage is compulsory for it to become a custom. So 10 days back there is something which you have been, which you found it. You cannot call it as a custom. Only when it has been from time immemorial that particular thing is to be followed, then only it is to be called as custom. Yeah. So such a custom can take the force of law. It can be called as a law because we don't know particularly from when it got started. So such things are valuable in nature. That is why even law recognizes such uh, long usage of any particular thing. Yeah. Most of the Hindu law is based on customs and practices followed by the people all across the country. Every Smriti has given importance to customs. So thus they have held customs as transcendent law and have advised the kings to give decisions based on customs after due religious consideration. So it is seen that even kings used to come to conclusion, or when they were sitting to adjudge a particular dispute to provide justice, they were supposed to take into account customs. So customs were given value first after giving importance to religious consideration. First religious consideration, then came customs. Yeah. So in this particular case, Ramanand case, which we call it as, so collector of Madurai versus Muttu Ramalingam. So here in this particular case, it was held that under the Hindu system, clear proof of usage would outweigh the written texts of law. So custom has that uh, power to outweigh the law. In the sense, custom will prevail over the law. Whatsoever is written in a book, okay, can be kept aside when there is existence of a particular custom, is what was told in this particular case, Ramnath case, collector of Madurai versus Muthuramalingam. So these are the facts of the case. In this case, uh, Muthuramalingam was a zamindar. Yeah, you can go through this case as these ppts will be shared with you. So this was the particular thing, like yeah, you can write the only held part, like what was told in that particular case. You are supposed to write just the judgment, because mostly these what do we say, facts are not needed. Yeah. Customs must have a long usage and must not be contrary to justice, equity, and good conscience. So, these three terms, justice, equity, good conscience, these three are the principles of natural justice. This is a very important answer. So, in your 3 years of LLB, these three terms you will find it in almost in all the subjects. So these three terms are justice, equality, and good conscience, which are nothing but principles of natural justice, which any particular person who is sitting on the seat of the judge is supposed to follow in any case. Okay, so all the laws, all the procedures, if they are against these three concepts, they are considered to be bad in law. Okay, yeah. So, customs must have a long usage and must not be contrary to justice, equity, and good conscience. In the sense, yeah. So, it must be self consistent and complete by itself. This was held by Supreme Court in Saraswati Ammal versus Jagdambal. Okay. So, yeah. Customs may be local, regional, or peculiar to a family. Uh, yeah. So, customs are of four types. Local customs. These are the customs that are followed in a particular area. So, in this particular case, Privy Council. Remember, before Parliament, I mean, before the Supreme Court, before Supreme Court came into picture, when India, uh, when India was under the rule of British, this was the High Court. Sorry, the Supreme Court, where usually all the cases. This was the highest court back then. So it was nothing but the Privy Council. So the Privy Council observed that a custom gets its force due to the fact that due to its observation for a long time in a locality, say in a particular locality. So in Hyderabad, there had been a custom which has been following since since the time of Nizams. So that particular custom becomes a custom and it will become a law. Okay, so custom has such an effect which is higher to law also seen in certain circumstances. Okay, now family customs. So these customs are which are followed within the family from a very long period of time. So these are applicable to families wherever they live. Okay, they can be more easily abandoned than any other customs. Yeah. So in case of Surendranath versus Hiramuni and Bikal versus Manjura, in both of these cases, the Privy Council, so we can understand that these cases are relating to pre-independence era. So Privy Council observed that customs followed by a family have long been recognized as Hindu law. Okay, yeah. So caste and community customs. So in India, we have many castes, many communities existing here. So yeah, these are the customs that are followed by a particular caste or a community. It is binding on all the members of that community or caste. Okay, binding in the sense all the members of the community are supposed to follow those customs. By far, this is one of the most important sources of law. So, for example, most of the laws in Punjab belong to this type. Custom to marry brother's widow. Okay, custom to marry brother's widow among certain communities is also of this type, and mind you, this particular concept is even seen today in North India, particularly in Punjab state. Okay, so there we can't call this marriage to be a wrong marriage or a bad marriage in the eyes of law. Okay, because this is a custom which had been coming since a long period of time. So even law has to keep quiet when such a case comes before it, because they will give high weightage to customs. Yeah. So the fourth kind of custom is guild customs. These are the customs that are followed by traders, trading community, merchant community. Like we see that they open their books of accounts on the day of Diwali or the next day of Diwali. Something is there. So it is their custom. So it is their customary aspect. So traders will have that. Yeah. So, what are the requirements for a valid custom? We have been seeing what is custom and all of that. So, what actually a custom is supposed to have for it to be called as a custom? So, it must be ancient. Ancient in the sense it should be, yeah, a custom is valid if it has been followed from hundreds of years. There is no definition of ancientness. However, 40 years has been determined to be ancient enough. Okay. Next requirement is continuous. So it is important that the custom is being followed continuously and has not been abandoned. So let us suppose there has been some break of 10 years in between. Then you can't call it to be as a custom. Based on such aspects, the judges will decide, yeah, whether it to be a custom or not. Thus a custom may be 400 years old, but once abandoned, once it has been not followed, it cannot be revived. You cannot apply it again. Yeah. So there should not be any sort of breakage. Certainty. The custom has to be clearly defined. It cannot be vague and confusing. Clearly defined in the sense not written in the books, but it is well known to the human minds. Who are following it knows about it, only then they are following. So that thing must be there. Reasonable. There must be some reasonableness and fairness in the custom. Okay. Yeah. Consistency. So there should be consistency between customs in the sense two customs which have opposing viewpoints cannot be considered as a valid one. Okay, so one custom is saying something, another custom is saying another thing. You can't follow that. Like both of them are opposite to each other, then it will not be a valid custom. And custom should not be against morality. Morality is nothing but good, bad, right, wrong, all these things. So it should not be against them. So it should not be morally wrong or repugnant. Okay. For example, a custom to marry one's granddaughter, hmm, has been held invalid in a particular case. So this particular example you can call it to be as against the morality. Okay. So in this case, Chitti versus Chitti, a custom that permits divorce by mutual consent and by payment of expenses of marriage by one party to another was held to be not immoral. Okay. In this particular case, this was held to be immoral. Now, another case, Gopi Krishna versus Jagu, a custom that dissolves the marriage and permits a wife to remarry upon abandonment and desertion of the husband was held to be not immoral. So, what is immoral and not immoral is to be adjudged by the court. Okay, judges will decide what is immoral and moral when so and so cases go before them. So, while applying their mind, they will see what are the essential requirements of a custom. Okay, so going through that, only they will decide whether a
One second.
particular
What is the meaning of a judge in
adjudged
as
in, they will decide
judges will reason,
what, yeah,
decide?
what they will decide on the whole after the end of the case. Yeah. Okay. So also custom is not against any law. If a custom is against any statutory law is something which is passed by a statute. Statute is nothing but a legislation. Parliament, what do we say? State assembly, whatsoever laws they pass are nothing but statutory law. So if a particular custom is against statutory law, it is invalid. Okay. Codification of Hindu law has abrogated most of the customs except the ones they that are expressly saved. So in this particular case, Prakash versus Parmeshwar, it was held that law means statutory law. So here, to put it very simple, any custom which is against the existing law is not a custom. Okay. Now, proof of custom. So the burden of proving a custom is on that person who is saying so, who alleges it, in the sense the person who is saying that this particular thing is a custom. So burden of proof lies on him. Okay. So usually customs are proved by instances. So usually they show the examples there, they will demonstrate them in the court of law. Only then the judges come to know. So in the case of Prakash versus Parmeshwari, it was held that one instance does not prove a custom. So you can't just show one example. You are supposed to show that this has been doing from a long time, and there are many such instances. Only then the court will come to a conclusion. Only then it will convince itself to say that particular thing as a custom. So, however, in the case of Ujagar versus Geo, it was held that if a custom has been brought to the notice of the court repeated, no further proof is required. Okay. So when many times a particular thing has been brought to the court of law, then there is no further proof required to be shown by the person, because the court itself will know that there is a particular custom existing in that place. Now, usage and custom. Usually, we get confused between both of these terms because they are commonly used interchangeably. So, those terms are usage and custom, but there is a distinction between both of them. So, a usage is a repetition of acts, whereas a custom is a law or general rule. Okay, so custom is a general rule. It is more powerful than a usage. So that arises from such repetition. So a usage may exist without a custom, but a custom cannot arise without a usage accompanying it or preceding it. So a usage derives its authority from the assent of the parties to a particular transaction and is applicable only to the consensual agreements. Consensual agreements, in the sense both of the parties are agreeing. Consensual arrangements, yeah. Consensual arrangements also mean the same, but both of the parties are agreeing. So, custom derives its authority from its adoption into the law and is binding regardless of any acts or assent by the parties. So yeah, this is to do with custom. So in simple sense, usage is which you are repeatedly doing, but custom is like a general rule or a general law which is coming since a very long period of time, and which has, I mean, which satisfies all the essentials which I have told just before now. Yeah. So, in modern law, however, the two principles are often merged into one by the courts. So, it is seen that both of the principles are merged by the courts. Now, the final thing which we are going to see under ancient Hindu law sources is the digests and commentaries. So, the fourth source of Hindu law are commentaries. So, what are commentaries? Commentaries, examples are given here: Tika or Bhasya. Yeah, sorry, commentaries means tika or bhasya. So comment, you all know what comment is. What is something already known, you are just commenting on that, you are writing a book on that. Okay, so that is to do with commentary. Like for law of contracts, we have commentary by Avatar Singh. Okay, he is a advocate. So what he told about law of contracts, uh, yeah, so there is a book. In the same manner, sages have come up with this thing, commentaries. So the other term is digests. Digests are nothing but nibandhas, what we can say it as essays or paragraphs. So commentaries and digests covered a period of more than 1,000 years, from 7th century to 1800 AD. So, in the first part of the period, most of the commentaries were written on the Smritis. As I have told you, Smriti's already known things on that what a particular sage is getting to know, because everyone understands the concept in their own fashion. So, what a particular sage has understood from the Smriti, he will write it down as a commentary. So, it will take, like if I am writing a commentary, it will be called by my name. Okay, yeah. So, in that manner, what is already existing, I am understanding it in my sense, writing it on that. That is nothing but a commentary. Okay, yeah. Now, after 200 AD, most of the work was done only on the existing material given in Smritis. The work done to explain a particular Smriti is called a commentary. Okay, so explanation of Smritis, okay, in their own fashion by sages. Different sages were called to be as commentaries. So, commentaries were composed in this particular period, that is after 200 AD. What are digests? Digests were mainly written after that and incorporated and explained material from all the Smritis. So these are like explanation versions which are given by sages to be called as digests. Yeah. Some of the commentaries were given by Manubhashya, Manutika, and Mitakshara. So while the most important digests are Jimutavahana's Dayabhaga, okay, that is applicable in the Bengal and Orissa area. So Dayabhaga and Mitakshara, this explanation will be dealing tomorrow. Yeah, so here superficially we are going to see Mitakshara literally means new word, okay, and is paramount source of law in all of the India. It is also considered important in Bengal and Orissa, where it relents only where it differs from sea. Dayabhaga is like Mitakshara applies only to particular areas, while Dayabhaga applies to whole of India. Okay, so it is very exhaustive treatise of law. So these both are nothing but they include some rules and regulations, some practices which are followed by people residing in that particular area. Okay, so some region people follow Mitakshara, some region people follow Dayabhaga. Okay, so these both are the two major schools of Hindu law. So the Dayabhaga is written by is a commentary of Jimutavahana and Mitakshara Vigneswara, Vignaneswara. Yeah. So yes. Now coming to the modern sources of law, we have seen the ancient sources of Hindu law. Now coming to the modern sources of Hindu law. Uh, Yes. So the first one, as I've told you, principles of equity, justice, good conscience are nothing to do with the principles of natural justice. Okay. So our judicial system greatly relies on being impartial. So how can you say that somebody is impartial? Only when he is showing equity, justice, and good conscience, in the sense when he is able to treat everyone equally. Okay, when he is being impartial, in the sense he is applying these three principles of natural law. Okay, yeah. True justice can only be delivered through equity and good conscience. Occasionally, it might happen that a dispute comes before a court which cannot be settled by the application of any existing law. Say there are no laws relating to a particular aspects, so how a particular judge is to decide on that matter? So he will straight away go to these three principles of equity, justice, and good conscience. In the same manner, when a matter comes before the court relating to Hindu law, and when there is nothing relating to that particular dispute in any of the laws which are existing today, say Hindu Marriage Act or Hindu Succession Act, so where will he, what will he do in that cases? He will go to the modern sources of Hindu law, the first principle which says principles of equity, justice, and good conscience, which are nothing but principles of natural justice, which any person is supposed to apply, which any judge is supposed to apply. He will apply those. So yeah, occasionally it might happen that a dispute comes before a court which cannot be, existing till today. So, in such a situation, may be a rare, but it is possible because Not every kind of fact or situation that arises can have a corresponding law governing it. So the courts cannot refuse to settle the dispute in the absence of law. They are supposed to come to the conclusion. So for determining such cases, the courts rely upon the basic values, okay, basic values, norms, standards of fair play, okay, and propriety. So this is known as the principles of justice, equity, and good conscience. So they may also be termed as natural law. Okay, yeah. So this principle in our country has enjoyed the status of a source of law since the 18th century. Okay, so when the British administration made it clear that in the absence of rule, the above principle shall be applied. So these three things, these three concepts came from British rule in India, 18th century. Now, what is a precedent? Yeah, the doctrine. So this is a in the second year, you people will be having jurisprudence. There you'll come across this term precedent. Yeah. So also this doctrine of stare decisis. Stare decisis is a Latin term which means abide by the decision. Okay, follow the decision, it means. So the doctrine of stare decisis started in India from the British rule. All cases are now recorded. New cases are decided based on existing case laws. Okay, so yeah, you will be seeing that in the court, advocates will be, referring to many Supreme Court judgments or different High Court judgments. So, what is all that? They are called to be known as precedents. Okay, so they are supporting their cases with the help of precedents. So, this particular source came into picture after the British rule. Okay, yeah. The doctrine of precedent based on the principle of treating like cases alike. So, yeah, it is easier, like for a particular advocate to put his case before the court. He is supposed to go through the similar cases, make them a part of his case, and make the judge convincing. Okay, so that is nothing but we call them as precedent cases. Okay, so on a particular matter, so if the Supreme Court has told something, he can include that. So he can call such a case as precedent case. Those are nothing but precedents. Okay, so today the judgment of Supreme Court is binding on all courts across India, and the judgments of high courts is binding on all courts within the state, except where there have been modified or altered by the Supreme Court. Okay, so in all the case, all the matters all the, what do we say, all the cases we usually see that old case laws, okay, existing case laws upon a particular subject or a particular matter are put forth. So all such old cases, all the old cases are to be called as precedents. Okay, so even these are the modern sources of Hindu law. Like you can, like the judge can say in that particular case, it has been the advocate can say that 3 years ago in that particular precedent case law, Supreme Court has told so and so. So please consider this case. Okay, so even that becomes the source of law at that particular moment of time. Okay, so based on that, decisions are given by the courts. Okay, now the third source of modern Hindu law is legislations. Legislations are acts of parliaments, the bills which, go on to become acts or laws passed by the parliament are nothing but legislations, statutes, statute law. All these are synonymously used. Okay, so which have been playing a profound role in the formation of Hindu law. Okay, so after India achieved independence, most important aspects of Hindu law have been codified. Now, yeah, codified in the sense they have been made into writing. They have been put into one head. Okay, that is to do with code. Yeah. Few examples of such statutes are the Hindu Marriage Act. Okay, what is a marriage? Hmm? What are the essential requirements of a marriage? what are the circumstances where marriage cannot be called as a marriage. Okay, all the essentials and all rules and regulations relating to marriage, okay, are dealt under this particular act, which is Hindu Marriage Act 1955. Okay, now the Hindu Adoptions and Maintenance Act, rules and regulations relating to adoption of a particular child, hmm, and the maintenance of such maintenance of wives and all will come under 1956 legislation. Then Hindu Succession Act, how a particular property is to be divided, okay, of a Hindu, is to be seen in 1956 Act. Then the Hindu Minority and Guardianship Act, okay. So all these laws applies only to Hindus. Yeah. So these are the acts which are passed by Parliament after independence. So all of them are written in nature. These are called as legislations. So all these are also modern source of Hindu law. So after codification, any point dealt with the codified law is final. Whatsoever is written in this law is final. No one can alter them. Okay. The enactment overrides all prior law. Okay. In the sense, whatsoever is written in enacted law, that is the above rules, acts, is full and final. Nothing can come as an obstacle in between, whether based on custom or otherwise. But then if customs come, it will be seen in their perspective only, like essentials will be seen into. Okay. Yeah. So scope and application of Hindu law. So Henry Maine, the jurist, has defined Hindu law as the oldest pedigree of any known system of jurisprudence, and even now it shows no sign of decrepitude. So this term you people go through. So he has told that Sir Henry Maine, he is the person who subordinated Lord Macaulay in the formation of many laws like the Indian Penal Code, Indian Evidence Act. So he is the person who assisted Lord Macaulay in the formation of IPC and Indian Evidence and Act and such other laws. So he says that Hindu law is the oldest one known to the system of jurisprudence. So the word Hindu first appeared in the Old Persian language, which was derived from the Sanskrit word Sindhu. Okay. So in who is a Hindu? Hindu is a person who follows Hinduism. So this is all relating to Hindu law. Many people have told many words, explained them. So yeah. So it is significant to note that the term Hindu is not defined anywhere. You go and see Vedas, Vedanganas, or even for that matter, any other books, you will not see that you can find the word Hindu, but you will not find like who is that person who is actually a Hindu. Okay, there is no precise definition given in any book. Okay, anywhere in terms of religion or any statute or judicial decision. Okay, for the purpose of determining to whom Hindu law applies, it is necessary to know who is a Hindu, and none of the sources expressly states so. Okay, now after seeing this difficulty, yeah, we finally got to know who is actually a Hindu. So from statutes, we can get a negative definition of a Hindu, which states that Hindu law shall apply to those who are not Muslims, Christians, Parsis, Jews, etc., and who are not governed by any law. This is a very important sentence, which says that so who is not governed by any law. Say some person is a atheist who does not believe in God. Okay, so even he comes under it. He is considered as a Hindu here. Okay, now so they expressly don't say who is a Hindu. They have just told ki who is not a Muslim, Christian, Parsi, Jew. He is a Hindu. Yeah, Hindu law is considered to be divine law, as we have seen. So it is strongly believed that the sages have attained some spiritual dominion and they could communicate directly with God. Yeah. From whom we get the divine law. This is only an assumption, and no concrete proof for the same is shown that the sages could communicate with God. Okay. Now, from where did origin of Hindu law came from? So there are two extreme views about the origin of Hindu law. According to one view, it is of divine origin. Okay, something we told like in our starting. While the other view is that it is based upon immemorial customs and usages. These are the two views which are the basis of origin of Hindu law. Yeah. Now, law according to Hindu jurists is the enforceable part of dharma. So, Hinduism is all relating to dharma. Law is dharma itself. It says the term dharma is understood to include the rules which govern the whole mankind. Okay, the word dharma generally includes all kinds of rules, religious, morals, legal, physical, metaphysical, or scientific, in the same way as the law does, in its widest sense. So, yeah, Hindu law is not a law as understood in modern times. A law is the present sense. A law in the present sense would mean an act framed by the legislature of a state. So previously, we had some other definition of law. That is the dharma. What is right, what is wrong, what is religious, what is moral. But in today's world, law is understood in another sense. That is law made by the legislatures. Okay. Yeah. Yes. So the Madras High Court has explained the term Hindu law in the following words. What is ordinarily understood as Hindu law is not like the customary law of the country, like the common law of England. In England, we have common law. Okay. So most of the Indian laws which you see today are children. I mean, we can say that they are from common law of the British. Okay. So, yes, so the Madras High Court had told neither is it a statute law in the sense that some king or legislature framed the law and enforced its acceptance by people. Hindu law, as is commonly understood, is set of rules contained in several Sanskrit books, which the Sanskritists considered as books of authority on law governing the Hindus. This particular sentence was passed in the case of Mukka Koni versus Amma Kutti by the Madras High Court. So they made this distinction with the common law of England. Yeah. So Hindu law occupies a prominent place in the field of jurisprudence. So they basically put their focus on dharma, which is nothing but duties, rules, and all of that. So yeah, based on the principles of dharma, the king is supposed to, I mean, dharma is to be the supreme thing which even the king is supposed to follow. And when he is supposed to judge any particular case, when any dispute comes before him, he is supposed to weigh both the sides by placing them in the balance, in the common balance of dharma. He is supposed to weigh them. Yeah. So we also see this the ultimate aim of life according to Hindu law is to achieve salvation or moksha. So Hindu law rotates all around moksha, dharma, all of such sorts. So yeah, previously it was seen all these things, but later on this law was applied to the Hindus by the authority of the following. So in those days we came across the term moksha and all of that, but in today's life, today's world, we see that all these things are modernized, and those things are a part of acts of the parliament. Any law which you see in those things, these things are included: imperial legislation, provincial legislation, principles of justice, equity, and good conscience. Okay, these are nothing but even the dharma principle sees that you are not supposed to do anything wrong, right? You're supposed to support only the good things. So even the principles of natural justice say so. Okay, so these are the Hindu, I mean, the old ancient terminology such as the moksha, dharma, and all of that. So the modern terminology is justice, equity, and good conscience, which is included in acts of parliament and all of that. Yeah. So Hindu law is not lex loci. Lex loci is a Latin term which means the law of the land or the law of the territory. Okay. So it says that Hindu law is not the law of the land, which means that any Hindu person, if he suppose he is going to some other country, even to him, Hindu law will apply. Okay. Now, Hindu law is not a territorial law in the sense people living in India, not only it is, yeah, territorial law in the sense it is just confined to India or any other particular state, but it is not so. It is not a lex loci, okay, but a personal law. Personal law deals with social life of any person. Okay. Social life is to do with divorce, marriage, maintenance, and all of those things. So it means that a Hindu, in whatever country he may be, is governed by Hindu law in all personal matters. Territorial law or that country would not apply on the personal matters or that Hindus. Okay. Let us suppose a person has shifted to USA. Okay, those countries USA laws will not apply to the personal matters of that particular person. Okay, in the sense his marriage, his divorce, all of those things will be based on Hindu law only if he is a Hindu by birth. Okay, yeah. Effect of migration. Hindu migrates from one part of the country to another. Where a Hindu migrates from one part of the country to another, the presumption is that he retains the laws and customs, the thing which I have told you. Okay, wherever a Hindu goes, he carries the provisions of Hindu law with him. Okay, so even if he files a case relating to divorce in American court, that judge is supposed to decide the matter based on the Hindu law only. I mean, any law which applies to that particular person for that matter. Okay, so application of Hindu law under the Constitution of India. This is Article 372 says that all laws in force in the territory of India immediately before the commencement of Constitution, that is 26th January 1950, shall continue until altered or replaced or amended by a competent legislature or other competent authority. Okay, after the constitution was adopted, four major acts came, the one which we have seen. However, the law relating to Hindu joint families, their partition and reunion, as well as the law relating to wills, gifts, religious usages, and institutions, continues to be derived from the ancient sources of Hindu law. So here you can see that we all know that marriages were performed even before the Hindu Marriage Act came into picture, right? So we can't call all of those marriages to be invalid today. Okay, because yeah, you can understand this. So the Hindu Marriage Act 1955 will just apply to those cases which are coming into, I mean, all those matters, disputes which are coming only after the passing of this act. Okay, so when there is any confusion relating to that, Hindu Marriage Act 1955 will be seen. Yeah. So who is actually a Hindu? It is difficult to define the term Hindu in reference to religion, since Hindu religion is so diverse and multifaceted. So, from the point of view of the application of Hindu law, Hindu I mean, the term Hindu is of a very wide connotation. So, in its ambit, the following are included. So, all those persons can be called as Hindus who are Hindus, Buddhists, Jains, Sikhs by religion. In this category are also included converts and reconverts to these particular things. I mean, these three religion, reconverts and converts to these religions. Okay, all those people are Hindus. All those persons who are born of Hindu, Sikh, Buddhist, or Jain parents. In case only one parent is a Hindu, then the child must have been brought up as Hindu. In this category are included both legitimate and illegitimate children of such parents. Okay, these are the three important things. All those persons who are not Muslims, Parsis, Christians, or Jews who are domiciled in India and to whom no other law is applicable. So these three
Madam,
points, yeah,
what is the meaning of illegitimate here?
illegitimate.
Hmm.
So these are those children uh, born out of unmarried parents, unmarried husband and wife, unmarried couple for that matter, illegitimate children. Yeah. So the Supreme Court of India in the landmark case of Shastri versus Mool Das expressly defined the term Hindu. This case is relating to Swami Narayan Temple in Ahmedabad. Okay. There are a group of people called Satsangis who were managing the temple, and it so happened that they restricted non Satsangis, Harijans, to enter the temple. So they argued that Satsangi is a different religion and they are not bound by Hindu law. Okay. They are saying that Satsangis will not come into the word Hindu law. I mean, they are not Hindus and Hindu law will not apply to them. So the Supreme Court of India held that the Satsangis, Arya Samajis, Radha Swamis, all these people belong to Hindu religion because they are originated under Hindu philosophy. Okay, here and there might be some sort of differentiation, but ultimately they are governed by the same dharma, same moksha, same self realization concept is there. So no matter whatsoever name they have, satsangis, arya samajis, or any other thing, they are under the Hindu philosophy only. So this was the landmark judgment which actually defined the term Hindu. So it gave a wider scope to the term Hindu there. Remember this case, Shastri versus Muldas, which you people are supposed to include in your answer when it asks the question, who is a Hindu? Yeah, Hindu by religion. If any person follows the religion by practicing it or by claiming it to be called as a Hindu, he can be a follower of any ancient or modern sect or subsect of Hindu. Okay, any mod sect in the sense division, any modern division or any subdivision of a Hindu. That's such a person who is practicing or who is claiming, who is just saying that he is a Hindu. Yeah. Thus, Vrishavites, Lingayats, Tantrics, Raidashis, Brahma Samajis, Arya Samajis, so and so people are Hindus as told by the apex court in these particular cases. So, any person who is a Jain, Sikh, or Buddhist, so
Madam,
any,
can I ask one doubt?
yeah,
What is the difference between Arya Samaj and Brahma Samaj, madam?
so these are both of them have different differentiation. Also, they have different objects, which I'll get back to you tomorrow.
Okay.
Okay, yeah. So, any person who is a Sikh, Jain, or Buddhist by religion is also a Hindu, since Hindu law applies to them, was told in these particular cases. And in the previous slide also we have seen that any person who is not a Muslim, Christian, Parsi, and all of them, to whom Hindu law applies, so the So the leftover religious people are Jain, Sikh or Buddhist. That is why they form the part of Hindu law. Thus, any person who follows Hindu religion in any of its form or development, either by practicing it or by professing it, is a Hindu. Hindu religion, that is why, is said to be a multifaceted one. Yeah. In other words, any person who is a Hindu, Jain, Buddhist, or Sikh by religion is a Hindu if he practices, professes, or follows any of these religions. And he remains a Hindu even if he does not practice, profess, or follow the tenets of any one of these religions. Okay. So even if he follows the principles, he is to be called as a Hindu. Even if he doesn't follow the principles of these religions, he will remain a Hindu because he is not forming part of Muslim, Christian, Parsis, and so on. Okay, as I have told you, even for those who don't believe in God, for them Hindu law applies. So, and codified Hindu law applies to all of them. So, people now, what is the situation of people who have changed religion? So, in this general principle of law, it is the general principle of law that a person who has accepted a religion cannot rely on a custom opposed to that religion. Okay, thus, where a Hindu converts to Mohammedanism, he will be, as general rule, governed by the Mohammedan law. But a well established custom in the case of such converts following their old law in matters of succession and inheritance has been held to override the general presumption. So here we see that several classes of Mohammedans who were formerly Hindu, like the Khojas and the Kutchi Memons of Bombay, the Halwai Memons of Kathiawar, all these are, subsects in Mohammedans, sects and subsects, in the sense divisions and subdivisions in the Muhammadans or the Muslims. And Sunni Bohras of Gujarat had by custom remained the Hindu law of succession and inheritance. So for so and so Muslims, I mean in these areas like Gujarat, Bombay, and all of that, uh, Muslims are called, I mean, some divisions of Muslims are called by some different names like Sunni Bohras, Khojas, and all of that. So, for them, when it comes to succession and inheritance, they follow Hindu law, it seems. Okay. So, but in view of the passing of the Muslim Personal Law Shariat Application Act 1937, the custom in the communities ceases, in the sense stops to be applicable, and these Muslim communities are now governed by. Okay, previously it used to be different, like Hindu law of succession they applied for themselves, but then now everyone, for everyone, in the sense Muslim, if he is, the Muslim Personal Law Shariat Application Act 1937 applies to them. Okay, in personal matters. Yeah. Now, in cases where Hindus have converted to Christianity, okay, before the passing of the Indian Succession Act 1925, such converted persons had to elect either to adhere, in the sense either to follow or to renounce the Hindu law of succession, but the act brought under its provisions all native Christians where they have or have not elected to remain to the subject of the Hindu law. So, yeah, Christians. So, any Hindu who got converted, you know, to Christianity before the passing of this 1925 act, they are supposed to make a choice here either to elect or to renounce, in the sense either to choose or to not choose Hindu law of succession. Okay, yeah. Now, what is the situation of the persons to whom Hindu law does not apply? Okay, the Hindu law does not apply to the illegitimate children of a Hindu father by a Christian mother and who are brought up as Christians. Okay, these are technical points. Okay, so you are supposed to, think for a minute so as to know the situation, and then only you can understand it very well. So illegitimate children, so a man and a woman who are not married, children born to them are called as illegitimate children. So to the illegitimate children of a Hindu father by a Christian mother and who are brought up as Christians, okay, or to illegitimate children of a Hindu father by a Mohammedan mother. Okay, father is Hindu, but the mother is, in one case is a Christian, in the another case is a mother, because these are not Hindus either by birth or by religion. We know that the religion of our father applies to us, right? So that is the thing here. So the Hindu law will not apply to such children whose mother are not Hindus. Okay. Now next point is to the Hindu converts to Christianity. So succession to the estate of a Hindu convert. Hmm? Sorry, succession to the estate in the sense property here. Succession to the estate of a Hindu convert to Christianity who dies a Christian intestate. Intestate in the sense he has not written a will, is governed by the Indian Succession Act 1865, which is now, you know, made into Indian Succession Act 1925. Okay, so a person stops to be a Hindu in religion, cannot, since the passing of the act. Okay, this is a technical thing. You just understand for now that to the Hindu law does not apply to the Hindu converts to Christianity. Okay. Now, now the Hindu law does not apply to descendants of Hindus who have formed themselves into a distinct community or sect without a peculiar religion and usages so different from the principles of Shastras that the community cannot be regarded as being outside in the proper meaning of the words. So, to also these people, the Hindu law will not apply. And the Hindu law will also not apply to convert from Hindu to the Mohammedan faith. Somebody who is a Hindu converted into Muslim faith. Also to them, the Hindu law will not apply. So, what are the situation of converts and reconverts? So, converts and reconverts are also called as Hindus. Okay, circumstances when a particular person changes his religion. Okay, or else he comes back to his religion. Okay, so even then they are called to be as Hindus. Okay, yeah. So a convert is a person who renounces his faith and adopts another. The usual way of conversion is by undergoing the ceremonies. Okay, so ceremonies are held so as to convert from one religion to another prescribed by such a religion to which the conversion is sought. Okay, for a Hindu to convert into Muslim, there will be some some ceremony to be held. But under Hindu law, a person does not lose his faith by mere renunciation of it. Okay, just by giving up, he is not, yeah, a person does not lose his faith by mere renunciation of it, nor does he belong to another faith by merely professing it or practicing it. Thus, if a person Christian by faith becomes an admirer of Hinduism, okay, so much so that he starts practicing and preaching it, he does not thereby become a Hindu. This is the turning point of this para. This is to be understood very clearly. Person Christian by faith becomes an admirer. Okay, he has got some liking towards Hinduism, so much that he starts to practice and preach it. Okay, so he does not thereby become a Hindu. This is a rule. The Dharma Shastras did not prescribe any ceremony for conversion to Hinduism. Any Christian person coming into Hinduism, he is, there is no such ceremony which is included in Hindu law. Okay, Hindus did not contemplate that followers of other religion would convert to Hinduism. Among the Hindus, it is only the Arya Samajis who prescribed the ceremony of conversion. Okay, so that ceremony was known as Suddhi. Shuddhi, I mean. So, in a series of cases, Supreme Court, in a particular case, gave a decision, which is Perumal versus Ponnuswami's case. It has been laid down that a person may also become a Hindu if, after expressing an intention expressly or impliedly. Expressly ante when he's speaking, when he's saying so. Impliedly in the sense when he's acting in a certain manner. Okay, not saying orally but acting in a certain manner. He lives as Hindu. Maybe he is, uh, maybe he have told somebody expressly in the sense saying to the world. Okay, declaring it to the world. Impliedly in the sense acting in a specific manner, showing in a specific manner. So he lives as Hindu, and the community or caste into the fold of which he is ushered in, I mean, where he is living in, accepts him as a member of that community or caste. In such a case, one has to look to the intention and conduct of the convert. Okay, these are the important lines. One has to look into the intention of that person, conduct of that converted person, and if the consensus of the community into which he was initiated is sufficiently indicative, when it is sufficiently indicating of his conversion, then the lack of some formalities cannot negate what is an accomplished fact. So, yeah, this was told in another particular case. So, in such a case, no formal ceremony of purification or expiation is necessary to effectuate conversion. It is immaterial to which class of Hindus the convert belongs, in the sense to any group of, I mean, to any class of Hinduism that person belongs to all of them, this thing applies. It is also not necessary to show that he practices or follows tenets of any sect or subsect of Hinduism. This was the finding, I mean, this was the law which was laid down by the Supreme Court in both of these cases, which is relating to converts and reconverts. Okay, based upon this, the Supreme Court told so and so we say that converts and reconverts are also Hindus. Yeah. The other things, like from here on, we'll see it tomorrow.